Rappers, they're just like us. They settle disputes the way we all do. And while since this is America, you might assume that's by murdering your contemporary with a gun, it's actually by filing dubious lawsuits. I'm looking at you, Drake.
Look, today was an obstacle course, okay? And I brought my A game.
Now with the song Not Like Us, Kendrick Lamar seemed to have struck the knockout blow in his long-running feud with Drake. The diss track reads Drake for filth, accusing him of being a pedophile,
certified lover boy, certified pedophile,
hooking up with Lil Wayne's girlfriend when Wayne was in prison,
fucked on Wayne girl while he was in jail, that's conniving,
and pretending to be from the streets when he's really just a rich kid.
You caught Future when you didn't see the club. Hey, what, little baby, help you get your lingo up. What, 21, get your first street cred.
The song surged to 900 million streams before Drake finally fought back. Instead of diss tracks, Drake filed 2 diss petitions claiming that companies affiliated with Lamar artificially boosted the popularity of Not Like Us with bots and payola. And he accused his own music label, Universal Music, of defaming his character by promoting the song. And news of Drake's legal filing sparked a, quote, massive 440% increase in the song's sales and a 20% rise in streams. And with all due respect to Mike Masnick, maybe it's time we retire the Streisand effect and just call it the Drake effect, or the Aubrey effect.
Yeah, Drake! Drake!
And this also means that Lamar is so good, he goaded Drake into filing legal diss tracks that are making Kendrick millions of dollars. And there's a lesson here, and it's this.
And if I've learned anything this year, it's that none of us, not a single one of us, not even me, should ever pick a fight with Kendrick Lamar.
They not like us, they not like us, they not like us.
Hey! He will make your hometown not like you. The next time Drake sits courtside at a Raptors game, they're gonna Forrest Gump him. Sight's taken.
This is true, and that's why LegalEagle is Team K-Dot. So we know Kendrick got the upper hand rhetorically, but does Drake have leverage in a court of law? Let's find out. Now there are several things that could eventually become lawsuits here. The first is Drake versus UMG and iHeartMedia, and I can't believe that Drake is forcing me to take the side of UMG. Ugh. But in Not Like Us, Lamar blasted Drake as a, quote, certified pedophile, and someone whose name should be, quote, registered and placed on Neighborhood Watch. At issue are the statements,
Say Drake, I hear you like I'm young. You better not ever go to cell block 1. Certified lover boy, certified pedophiles. Why you trolling like a bitch, ain't you tired? Trying to strike a chord and it's probably A minor.
Now these are references to allegations that Drake has had relationships with underage women. Drake, of course, denies those allegations.
I'm way too famous for the shit you just suggested. Drake is not a name that you gon' see on no sex offender list.
And when people heard the song, they quickly picked up on the accusations and wondered whether Drake would sue Kendrick Lamar for defamation. But Drake hasn't so far sued Lamar. Instead, he filed a pre-suit discovery petition against iHeartMedia and United Music Group, accusing those companies of knowingly damaging Drake's reputation by releasing the song. The petition was filed in Texas, where iHeartMedia is headquartered and where Drake is domiciled. In Texas, Rule 202 of the Texas Rule of Civil Procedure allows a person to request permission from a court to take depositions before a lawsuit is formally filed. Now, the purpose of this kind of petition is to determine whether there are grounds to file a lawsuit and who the proper parties might be. Now, usually discovery happens after the lawsuit has already been filed, but there are limited circumstances when you can request discovery before filing the lawsuit itself. And according to this petition, UMG approved the release of Not Like Us, despite knowing that its lyrics, cover art, and music video besmirched Drake's character. Quote, before it approved the release of the song, UMG knew that the song itself, as well as the accompanying album art and music video, attacked the character of another one of UMG's most prominent artists, Drake, by falsely accusing him of being a sex offender, engaging in pedophilic acts, harboring sex offenders, and committing other criminal sexual acts. Drake argues that UMG had the ability to prevent his reputation from being damaged. Quote, pursuant to its rights under various contracts, UMG has exclusive control over the licensing of Not Like Us and could have refused to release or distribute the song or require the offending material to be edited and or removed. But UMG chose to do the opposite. UMG designed, financed, and then executed a plan to turn Not Like Us into a viral mega hit with the intent of using the spectacle of harm to Drake and his businesses to drive consumer hysteria and, of course, massive revenues. That plan succeeded, likely beyond UMG's wildest expectations. And it appears this conspiracy goes so deep that Drake himself is on it, because by filing this petition, he's driving tons and tons of more listens to the song that he hates so much. Now, there were tons of headlines about this case saying that Drake sued Universal Music for defamation, but that's not true. The petition only mentions defamation once in paragraph 17, where it says that Drake might have enough facts to file certain tortious claims against defendants, including but not limited to defamation. That's not the fiery response to pedophilia allegations that some hip-hop fans expected from Drake. especially since Not Like Us wasn't the first time Lamar called Drake a pedophile. On May 4th, Lamar released Meet the Grahams, a scathing critique of Drake and his parents, Sandy and Dennis Graham. He says Drake's company employs sex offenders who keep him on monthly allowance.
He got sex offenders on Hovio that he keep on a monthly allowance.
Lamar also addressed Drake's son Adonis.
Dear Adonis, I'm sorry that man is your father. Let me be honest. It takes a man to be a man. Your dad is not responsive. I look at him and wish your grandpa would have wore a condom. I'm sorry that you gotta grow up and then stand behind him. Life is hard, I know. The challenges always go beat us home.
And he alleged that Drake has a secret daughter.
Dear baby girl, I'm sorry that your father not active inside your world.
He blamed Drake's parents for raising a horrible fucking person.
You raised a horrible fucking person. The nerve of you, Dennis. Sandra, sit down. What I'm about to say is heavy. Now listen.
And ouch, even in art, those are serious claims. But Drake has not so far sued over any of them, at least not yet, in part because Kendrick Lamar has good First Amendment defenses. He has the right to express an honest opinion about Drake as a public figure, as long as that opinion is not intentionally spurious and malicious. And if you've watched this channel before, then you probably know that when someone makes offensive comments about a public figure, the public figure can only sue if they can prove the statements were made with actual malice. And in this context, actual malice means that the statement was made with knowledge of its falsity or with reckless disregard for the truth. And this is a much higher standard than for a private individual and requires evidence that the defendant acted with intentional or extreme disregard for the accuracy. And that's particularly hard if your opinion is based on revealed public facts. Now, we talked about this at length in the video about Cardi B's defamation lawsuit against the YouTuber Tasha. In over 30 YouTube videos, Tasha K falsely claimed that Cardi B was a prostitute, used drugs, and had contracted sexually transmitted diseases. A jury found that these were false allegations that caused significant harm to Cardi B's reputation and emotional well-being. The jury found that Tasha acted with actual malice. They awarded Cardi B over $4 million in damages. So if Drake sues Lamar, he'd have to prove that Lamar knew that Drake was not a sex offender or made defamatory statements with a reckless disregard for the truth. But this case is not directly analogous to Cardi B's defamation case because Lamar offered his commentary about Drake in the context of a song. Song lyrics often feature metaphor, hyperbole, and creative expression, which courts generally don't interpret as factual statements in defamation cases. For example, in 2005, the U.S. Court of Appeals for the Sixth Circuit ruled that rap lyrics performed by George Clinton did not defame record producer Armin Baladian. Clinton referred to Baladian as,
"He's a disgrace to the species, into his face with some feces."
Judge Alan E. Norris, writing for a 3-judge panel, said, quote, "There was no specific allegation, such as an act of child abuse, that could be proven. For instance, the statement that Armin is a disgrace to the species represents the kind of puerile taunt that, for better or worse, is typical of rap music." The court said, quote, "Even speech that is crude, what the court calls rhetorical hyperbole, vigorous epithet, and loose figurative or hyperbolic language merits protection." The court also dismissed claims against retailer Meyer. The court ruled that Meyer, as a distributor of the album, could not have had prior knowledge of the allegedly defamatory content. If distributors were held liable, this could discourage the free exchange of ideas, thereby chilling protected speech. So is Drake's potential defamation claim more like Cardi's or like Clinton's? Well, Lamar could argue that his comments about Drake were never intended to be factual, that both he and Lamar have created fictional personas, and that the person referred to in the song is a character. He could also state that he was making exaggerated comments about Drake in order to win a rap beef, and he could argue that Drake didn't suffer any damages because the hip-hop fans are well aware of how rappers use hyperbole. But in response, Drake could argue that his case is more like Cardi B's because Lamar made specific allegations about Drake having sexual relationship with minors, and these allegations hurt his reputation. Everyone is talking about these claims, and the more people who listen to the song, the more widespread the belief that Drake is interested in underage girls. Now, obviously, if you're going to torture your tough guy rap persona and file a dubious lawsuit, you'll want a good lawyer. Probably one that tells you not to file that pre-lawsuit petition. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you've gotten a data breach letter saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or find you the right attorney who can. It's so important to talk to a lawyer right away so you can maximize your recovery. And by the way, we don't get paid unless you do, and there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below. But it's unlikely a court would hold UMG responsible for distributing and promoting the track. In the Clinton case, the court did not hold Meyer responsible for selling the album because, quote, "The complaint makes no claim that Meyer had any familiarity with the lyrics prior to distributing the album containing them, but instead premises liability upon the act of distribution to an internet audience. This is not enough. To hold otherwise would be to impose a duty on retailers of books and music to screen those products for potential defamatory material. Not only would that burden be onerous, it could potentially have a chilling effect upon protected speech because retailers, in an abundance of caution, might stop selling some categories of artistic products, such as rap music, to avoid liability. But Drake would counter that, unlike Meyer, UMG knew the content of the track that it distributed and arguably helped produce it. However, UMG represents both artists, and both artists knowingly engaged in a years-long rap battle, and that opens up the possibility of using consent as a defense. And there's yet another wrinkle here. In Lamar's song 616 in LA, he claimed to have a mole inside of Drake's management company. He said the mole was spilling the tea about all of Drake's dirty little secrets, and Drake responded by saying that he worked with the mole and, quote, "We plotted for a week and fed you the information about Drake's allegedly secret daughter." So Drake says the supposed mole was more like a double agent. If this is the case, and there is evidence that Drake fed Lamar lies, that would cut against the claim that Lamar knowingly spread malicious lies. But Drake also accused UMG and iHeartMedia of payola. Now, payola is the practice of secretly paying or offering incentives to broadcasters, music platforms, and other intermediaries to promote specific songs, artists, or content without disclosing the arrangement to the audience. The term comes from combining pay and Victrola, a brand of early record players, and the term became widely recognized in the 50s and 60s during the radio era, when record labels would pay radio DJs to play certain songs more frequently. Now, arguably, there's nothing at common law that would prevent paying someone to play a song, but these days, payola is illegal. Under 47 U.S.C. 317, the law states, all matter broadcast by any radio station for which any money, service, or other valuable consideration is directly or indirectly paid, or promised to, or charged, or accepted by the station so broadcasting from any person shall, at the time the same is so broadcast, be announced as paid for or furnished, as the case may be by such person. And under 47 U.S.C. 508, it's illegal for a broadcaster to knowingly air paid content without disclosing the sponsorship or payment arrangement. And the disclosure has to be made at the time of the broadcast. This rule applies to individuals involved in the creation, production, or distribution of broadcast content, including employees and agents of the broadcaster. And payola is arguably bad because it misleads the public into thinking that an artist is popular through merit, word of mouth, when in fact a label is paying to promote that artist. And it hurts musicians who aren't signed to major labels because they don't have the resources to promote that work. And in the modern streaming era, payola has taken on new forms, like paying streaming platforms, playlist curators, or influencers to artificially boost streams, likes, or placements in popular playlists. And that's why the Federal Trade Commission regulates influencer marketing. In February of 2020, the FTC released guidance stating that, quote, when companies launder advertising by paying an influencer to pretend that their endorsement or review is untainted by a financial relationship, this is illegal payola. And in his other petition against UMG, which we'll get to in a minute, Drake alleges that there is a conspiracy by UMG and possible third parties to use payola to boost Not Like Us. He says, quote, petitioner has learned of at least one UMG employee making payments to an independent radio promoter who has agreed to transfer those payments to certain radio stations and or radio station employees. These radio stations subsequently played Not Like Us, and to petitioner's knowledge, did so without disclosing to their listeners that they had been paid by UMG to do so. Now, Drake says he hasn't been able to, quote, confirm whether any iHeartRadio stations were among the stations paid as part of UMG's pay-to-play scheme, or whether there were any direct payments from UMG to iHeartRadio to promote Not Like Us. But he goes on, quote, given iHeartMedia's status as the #1 audio company in the country, petitioner believes that UMG engaged in similar tactics to drive radio play of Not Like Us on iHeartMedia stations. And Drake claims that a whistleblower backs up his claims, quote, one whistleblower, whose identity is unknown, revealed publicly that someone from management paid him thousands of dollars on May 6, 2024, to use bots to achieve 30 million streams of Not Like Us on Spotify in the days immediately after its release to turn Not Like Us into a crazy hit. Bots appear to be real social media accounts, but are in fact software programs designed to mimic human behavior. And the petition cites this video from YouTuber Jamisco Dawn.
Relationships with them and their label and their managers.
Okay.
So there's certain people who I would never do that to out of respect. But the most recent song I did do all the bots for, well, most of it and the marketing was Not Like Us.
So the upshot of this petition is that he has enough smoke to think that there's a fire, and he needs the court's permission to get information that would back up his claims. And there's another interesting piece to this potential lawsuit. Drake is signed to Republic Records, which is a subsidiary of UMG, so in this petition he accuses his own label of radically departing from industry norms to boost his rival. Quote, in order to create incentives for high visibility influencers to spread Not Like Us, in what appears to be a radical departure from long-standing internal policy at UMG, UMG removed copyright restrictions on Not Like Us on YouTube and Twitch, thereby whitelisting the song. So the idea is that YouTubers could use a song without paying a fee, which would boost its reach. Although from my perspective as a YouTuber, that's kind of a stupid idea, because if you use copyrighted music, your video often gets demonetized, but that doesn't change the reach of the video itself. Unless a label actively blocks the video that uses the copyrighted music, it'll get exactly the same distribution as it would otherwise. And monetization has no effect on the search and discovery algorithm. So what does Drake want the judge to do? Well, he wants to be able to conduct pre-suit depositions from representatives of UMG and iHeartMedia. And this is typical of civil suits. The plaintiff usually asks the defendants to identify the people who have information relevant to the plaintiff's claims, and those depositions are treated as if the anticipated lawsuit has already been filed, following the same discovery rules applicable to non-party depositions in active cases. And in New York, Drake filed a petition for pre-action discovery against UMG and Spotify. The petition alleges that UMG engaged in deceptive practices to artificially inflate the streaming numbers of Not Like Us, and this filing is not the same as a lawsuit. Section 3102 of the New York Civil Practice Law and Rules allow a potential plaintiff to obtain discovery before filing a formal suit, and plaintiffs typically use the pre-discovery filings to preserve critical evidence or assess the viability of a claim. And a party seeking pre-action discovery has to file a motion with the trial court in New York, and it's not meant to be a fishing expedition. A potential plaintiff must ask the court's permission, and the court has the discretion to grant or deny the request based on the merits and necessity. And here, Drake claims that UMG used bots and payola schemes to boost Not Like Us, which hurt his career. UMG allegedly offered Spotify reduced licensing fees in exchange for disproportionately promoting Not Like Us. Quote, streaming and licensing is a zero-sum game. Every time a song breaks through, it means another artist does not. UMG's choice to saturate the music market with Not Like Us comes at the expense of other artists like Drake. He says the company's paid influencers, radio stations, and others to inflate the track's performance metrics without disclosing these payments. And the defendants allegedly used bots to simulate streams, creating the appearance of greater popularity. And Drake says that if he can get the discovery, he can prove the defendants violated the Racketeer Influence and Corrupt Organizations Act, which is known as RICO, as well as New York's Deceptive Business Practices and False Advertising Acts. Drake believes, probably incorrectly, he has a viable civil RICO claim with predicate acts of wire fraud, mail fraud, and/or bribery for UMG's payments to unknown third parties in the form of reduced licensing fees to Spotify. But his lawyers need information from defendants to prove it. Quote, specifically, petitioner requires information about the method by which the third parties were paid in order to determine which underlying predicate acts to plead, and requires information about which benefits were conferred upon UMG in exchange for the payments. Additionally, petitioners lack sufficient information to identify the third parties who acted in conspiracy with UMG. And Drake says these practices harm consumers and violate General Business Law Section 349, which prohibits deceptive or misleading acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of services in New York. Now, Universal Music told TMZ, quote, the suggestion that UMG would do anything to undermine any of its artists is offensive and untrue. We employ the highest ethical practices, in our marketing and promotional campaigns. No amount of contrived or absurd legal arguments in this pre-action submission can mask the fact that fans chose the music that they want to hear. So do Drake's claims have any merit? So far, they look pretty tenuous. The petitions admit they don't have enough evidence at the moment to substantiate the legal claims, and Drake would need concrete evidence of intentional manipulation and direct link between the manipulation and damages. But it's also possible this pre-suit discovery might turn up some smoking guns. And alternatively, maybe he has an ulterior motive and he just wants to get out of his contract with UMG. And for that, I can't blame him. But this kind of pre-suit discovery is pretty rare, so it's unlikely to go too far. So Drake lost the rap battle, made himself look like a wuss, and ultimately probably won't have anything to show for it. Now, whether or not UMG actually whitelisted Kendrick's song or not, dealing with bogus copyright claims is something that all of us creators have to deal with, which makes being a creator really difficult when you're dealing with popular media like movies or music, which is why my friends and I created today's sponsor, Nebula. On Nebula, you can watch all of our videos ad-free and early, because our videos always go up on Nebula first. Plus, there's tons of exclusive content, and we don't have to deal with bogus content ID claims. On Nebula, you can watch all of our videos ad-free and early, because our videos always go up on Nebula first. Plus, there's tons of exclusive content. For example, the Nebula version of this actual video features a LegalEagle version of the Kendrick diss track. Psst, I sue dead people. And of course, we don't have to deal with bogus content ID claims. And for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest deal of all. I know tens of thousands of you sign up for Nebula using the Curiosity Stream bundle, but as you probably know, that's over. So if you want to support this channel, the only way to ensure that the money you spend on Nebula goes to us directly is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. I've heard it described as Netflix for people that like trains, with your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and of your most favorite, LegalEagle. And exclusives on Nebula are getting really good. Recently, I enjoyed watching the Riff Tracks commentary over Plan 9 from Outer Space. It was the perfect video for Halloween. And how cool is it that a lot of the former Mystery Science Theater people from Riff Tracks are now on Nebula? And you can see my feature-length documentary, Bad Law Words Good, my other Nebula exclusive content, including the full-length interview with the screenwriter of My Cousin Vinny, and of course, not safe for work videos about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters. And because it's a subscription service, we can get to work on larger, higher budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood level production value without Hollywood level BS? And for those of you that want to share everything Nebula has to offer with your friends and family this holiday season, Nebula is now offering annual gift cards. If you sign up using the link that's on screen right now, you can give a year of Nebula to a friend for 40% off the yearly subscription. A year of the best content for just $36. And that's a gift that you can give to yourself, by the way, because you deserve it. So get 40% off of you or a friend's yearly subscription for just $36 a year. That's $3 a month for all of your favorite content, or you can check out the lifetime deal where for $300 you get access to Nebula forever. We're investing in more big concept, high octane Nebula originals, and your lifetime subscription goes towards that investment. In a way, lifetime is the best possible deal of all. Either way, you'll get all my videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on our own streaming site. So sign up now and get 40% off of the yearly deal, or get the incredible lifetime deal by clicking on the link below. Then after that, click on this box over here for more Legal Eagle, or I'll see you in court.